Well, Walmart CEO popped up today, so I thought I would pop up too. All right, certification of a class action lawsuit rule 23. Walmart stores v. Duke 564 U.S. 338 in 2011 U.S. landmark decision by Supreme Court. The Supreme Court. I didn't feel, nor many of the associates felt, that Clarence Thomas could be objective on a case brought by 23 people. That number is important. In regards to this case of women, that's very important. Women who allege gender discrimination in pay and promotion at Walmart. Clarence Thomas should have recused himself because we felt he would not be objective or fair to these women because Anita Hill and Clarence Thomas was involved in a highly publicized and controversial case during Clarence Thomas' confirmation hearing for the Supreme Court in 1991. Professor Hill accused Thomas of sexual harassment. They both worked at EEOC, Equal Opportunity Commission, and the Department of Education. This sparked a national conversation about sexual harassment, workplace behavior, and gender relations. Despite Professor Hill's testimony, Clarence Thomas was confirmed by the Supreme Court and has served on the Supreme Court since then. Same Senate that are stripping away women's rights. Clarence have worked on the Supreme Court now for 33 years. Old baggage. Now, Rule 23 is significant because it refers to the 23 named plaintiffs who originally brought the lawsuit against Walmart on behalf of themselves and a proposed class of approximately 1.5 million women who alleged gender discrimination in pay and promotion practices at Walmart. So, we started out with 23 and 1.5 million women joined the pack. Could this case proceed as a class action lawsuit representing all the women who claim to have been affected by the alleged discrimination? Well, the Supreme Court ruled in Walmart's favor, stating the certification was not appropriate due to commonality among the proposed class. Yes, we're going to get to commonality. Number 23, numerosity. Exact number of individuals can vary depending on the jurisdiction. They must have a sufficient large group. It would be impossible to bring individual class suits. Now, we went from the number 23 to 1.5 million women. So they have to streamline the legal process and provide for an efficient way for the large group of people with similar claims to seek justice or compensation collectively. Factors considered: the size of the class, geographic dispersion of class members, and the feasibility of joining the class members in the single lawsuit when determining the number required. Remember, 23, 1.5 million women. Like I say, they jumped in. Commonality. Legal or factual issues among the class members. Typicality. The claims of representative parties and typical of the class. In other words, the people or representative parties' legal claim and circumstances must be substantially similar to those of the class members in terms of facts and legal issues involved in the case. We can't have one person over here complaining or having an issue with apples and the other person complaining that it's not apple, it might be oranges. They all have to kind of align together, all right? Now, to ensure the requirements to ensure the interests of the representative parties align with the interests of the class members, and the representative party adequately represents the entire class. So the 23 people that came and filed the suit. Now, later on, 1.5 million women jumped in. That means that the 7 people that brought the suit, whatever they're claiming, then it has to be representative of the other 1.5 million. All right. And if your class action suit is not or significantly different of other class members, it may suggest that the representation of the party does not adequately match or represent the interests of the class. You will not be certified. Typicality is to promote fairness and efficiency and align that the party claims are represented by the broader class, and that they can effectively pursue the interests of all class members in a consolidated legal action. Because the people that brought the class, the 23 people, got to also be representing the 1.5 million women that's not there. Superiority requirements mean the best way to resolve the legal claims of multiple individuals who have similar grievances against the defendant or the defendants. Okay. Now, key requirements for certification. Several factors considered: fairness and efficiency, individual classes versus class action, to streamline the process by consolidation to one big case, because it would be better to have one whole case brought together than it would be almost impossible to hear 1.5 million cases of the same complaint. Manageability, the number of members, geographic dispersion, complexity of the legal problem, administrators which is feasible. Now, that will give notice to the class members, identifying and defining class members who are included. Manager case, can all the information coordinating discovery, motions, proceedings involving large numbers of parties be all pulled together? Now, the class members' participation, can the class members be able to participate, or will there be challenges? And we saw in the case before us, there was a couple of challenges, and some of the people, couldn't be there, although that wasn't a class action lawsuit, just one person sitting in front of Judge Mashan. There you go. But there were some challenges. Okay. Now, the distribution of damages. If the class action is successful, damages are awarded. Distribution of funds in a fair and efficient manner. Practicality, will it be better to settle the claim in a class action suit or individually? You will be denied if the courts decide it is not feasible to proceed too different, impractical, or it just don't align. It just don't match up. Adequacy of representation. The court will evaluate whether the names of the plaintiffs and their attorneys can represent the interests of the entire class. So those 23 people and their attorney just can't go rogue. They have to protect the interests of the members who are not there. 1.5 million women not there. Now, consistency of judgment. Single class actions can promote consistency in the legal rulings and judgments, which may be more efficient than having multiple courts deciding similar issues in separate lawsuits. availability to solve the problem and have methods and ways to solve the problems of the individuals in the lawsuit, alternative dispute resolution devices. Or would it be better to resolve the issues by a class action lawsuit? Certification of a class action lawsuit under Rule 23. Under Rule 23, the court must determine that proceedings as a class action lawsuit is efficient, fair, to solve the legal issues of the individuals or group with the similar issues, to ensure effective ways of resolving legal claims involving multiple plaintiffs. Now, with all that being said, the bottom line is we went from number 23 to 1.5 million people. And the kind of way Walmart operates, whatever those 23 people may have brought to the class, there might have been several complaints going over, which with Walmart I can understand. And it's hard when I see the word allegedly, because a lot of the complaints that were brought forth have been documented over and over and over again. But the problem is, just like the case before us in the Supreme Court, even if that information was brought, the actual cause of what happened when this case was filed may have been totally ignored. Now, the problem that I had and many associates had is, how in the world could Clarence Thomas be on a case that was about women, and he was going before his tribunal, his confirmation hearing with Anita Hill? When did he have time to step back and give himself a break and not be angry about what Anita Hill had revealed to his peers and basically to the world? Now, he should have never been on that case. He should have never been on that case. But Lawrence, who was there to police Thomas or police the Supreme Court or even police doctors, that's a big scope. But I strongly felt that when this case was brought, and I took it serious, I read, I looked up information. I thought, can anybody see that this man is more than pissed off? And when this ruling comes down, I don't care if it's from 23 to 1.5 million, he should have never been on that case. Never. And that's something else that troubled me also. And I want to go down my roll call list. My roll call at Legal AF. Now they got new conduct codes. Will Clarence Thomas follow these new conduct codes? And then there's the problem with Clarence and his wife. They're all over the place. They've made all kind of money. And it has been shown that his wife, Ginni Thomas, paved the way to organize the insurrection. This is gone from one case to many cases that he has been on and should have stepped off. And it didn't happen. And I don't know why he's up there now. Because there's no objectivity with this man. Glenn Kirshner, you're right. It is a cancerous spread. That's an underlying factor. And who better knows about cancer? Look into the camera. You're right. Absolutely. And hope that it never come back and catch up with me. Now, if a fine goes down, like I was listening to you, you said it could be a fine of $1,000, a fine of 30 days in jail, and it may possibly be a Class E felony. You also stated, Kirshner, that across the board, if he ends up being punished or violation, this could affect federal, state, and local. And that was explained to the predecessor by Judge Mashan. Brian Taylor Cohen, legal breakdown. I am there, and I do agree with a lot of things on your podcast. I'm a faithful viewer. Now, I also like to call out Andre Fonte for the practices. When he said, practice what you preach, I thought, well, you go ahead and sing Barry White's song, because they are not practicing what they preach. And shout out to you. And he's the Secretary of State of Arizona for the 18 charges in Arizona fake election plot. I guess that's another catch and kill deal. But they're holding people accountable. Now, we got to get rid of the filibuster. And I'm glad Minnesota is coming up on their voting rights. Andrew Weissman, Adam Klassman, Timothy, is that Heapy or Heppy, when you talked about underlying crime, Harry Littman, sleaze merchant. Absolutely. I totally agree with that. And Judge Mashan, yes, enough is enough. And you have bent over backwards. And regardless of your intention, people, regardless of your intention, human beings, their behavior are complex and unpredictable. And sometimes you can help, you can go that naked mile, you can try to hold back and think about, weigh every decision, and things just don't pan out the way you hope that they will. But I'm going to close it out because that was my roll call. And specifically, I wanted to be serious about Rule 23, because shouldn't we all be running around filing Rule 23? The whole nation, we're unprecedented, and our democracy is at stake. And we all got a common interest. The whole nation has a common interest. We all qualify. Everything that was listed under Walmart v. Duke, we all should qualify for commonality of democracy. The number is going to be massive, absolutely, because it's everybody in the nation. I would like to see that play itself out. That would really be phenomenal. But I just wanted to know that I wanted you guys to know that I'm taking in all this information. It's a lot to learn. I kind of had a jump start for working with Walmart, because after that lawsuit, after the decision of Walmart v. Duke, I was blown away. I get it about the numbers and getting the lawsuit thrown out, but whether it's thrown out, I just didn't feel, bottom line, that Clarence Thomas should not have been on that lawsuit. He should not be making decisions going forward, and he should be kicked off the Supreme Court. That's it. Whether if I got all my info, I'm not trying to give out any misinformation, but that's my bottom line. Clarence Thomas should not be on the Supreme Court making any more decisions. And that's it. And thank you for listening.